Dr. David Clark.
Yeah, I confess I was looking to hear what Darian Fenton was going to say, and was on she was on the cusp of really kind of getting to the grips of what the mass arrival issue was, and it's something that's been troubling me, just how that will be defined, and I hope she has another opportunity in the debate to further expound that, because, Mr. Chair, this is an important debate. I made the point in part one, so I won't labour it now, that you know, this is a bill which is attempting to distract from the scandals in the government, and you know, I guess I want to carry that on insofar as in part two we actually have the practical application of that. We have the consequential amendments in part two, which give effect to the things through other legislation. And if we imagined for a minute that some of those things were different in part two, we would get to a different outcome. We'd actually get a bit more chaos if the consequential amendments weren't followed through. And arguably, Mr. Chair, that would actually be a better outcome than having a consequential amendments that reflected the legislation, because it is such a poor piece of legislation. It is such a poor piece of legislation. So if we see, for example, in section 116, in the case of a person detained under a mass arrival warrant issued under, and it's got section 317B, I mean, if that number was wrong, then this legislation would not be able to be enacted in the same way. And I am interested if the Minister will get to his feet to suggest otherwise, because these amendments in here, for example in section 117, replacing the word earlier with earliest, puts a different emphasis in the legislation. This is all designed to ensure that this legislation is effective when it's put in place. And we in the Labour Party think this is a bad piece of legislation. So it seems that the actual best outcome would be for part two to be ineffectual, because that would lead to a fairer and better outcome. There are plenty of opportunities. My colleague Darian Fenton's SOP that would see people referred to a refugee centre, you know, the current arrangement that's in place, and a much more humane way of dealing with the issue rather than the hysteria being cranked up by this minister, following others in his caucus, in order to distract from the real issues in the country. A government that's propped up by support parties that are troubled. One that's in court at the moment, one that's been stepped back from a ministerial post, and another party that's squabbling amongst themselves about who is leader. We have a mess in the government, and of course Aaron Gilmore, who's just gone. This is the government that's struggling, and so we see them prioritising legislation that is actually not good for New Zealand. Not good, and they don't like it across there. You can hear them interjecting, Mr. Chair, because they know it's true. And I'd be embarrassed too. If you look across there, you'll see some red faces. Some of those backbenchers, they are embarrassed about this legislation, Mr. Chair. They're embarrassed about part two. They know what happens when part two gets enacted, and they know that they sign their names to this kind of legislation, this kind of knee-jerk response that is actually not good for our country and is not good for our reputation as a humane and hospitable place where refugees are treated with respect and integrated into the culture. So those people across the House there, I tell them this is a bit of a day of shame. This is John Key's attempt to channel John Howard with a bill that politicises the treatment of refugees and asylum seekers. It's divisive, it's destructive, and it does nothing to address the real issue. And we've got to ask ourselves, what's changed? What's changed? In 2011, John Key said that New Zealand was ready to deal with a boatload of asylum seekers. Ready. Should one make it to our waters? And he knew that was never going to happen. And what's changed since 2011? Apart from John Key's plummeting popularity, and that's why they're exercised over there, they know that John Key is becoming unpopular because this kind of knee-jerk reaction, this kind of knee-jerk legislation is the only thing that's going through the House. There's actually not anything that's qualitatively changing things. We know this government's got the worst economic record in 50 years, and there's no legislation being progressed to address that very important issue, and they know it's true. They know it's true across the House. That's why they're exercised. That's why they're embarrassed about this legislation. And John Key said, look, we've upgraded our operating manual. We can deal with this immigration issue. We're confident we understand our legal position. Well, something's changed since. Something's changed since, and it's the popularity of the government. And so that's why this legislation is being pushed through, to try and distract from the real issues, Mr. Chair. Mr. Chair. Mr. Chair.
I want to make a contribution about where the debate is going. Just because the debate mentions mass arrivals, the debate is about the consequential effects of the sections, clauses 16 and 17. And it doesn't open up the whole debate about mass arrivals. It's about the consequential amendments. Sue Moroney.
Yeah. And